ki atai e ake an he tu he hauhu ti he morio. Thank you, and could I welcome a number of parties here this morning, particularly our submitters, those people who did submit, and in particular the 15 who chose to come along and present today. We value your input and thank you for taking the time to come and talk to us. Just to welcome and introduce our panel, on my right here, Mayor Burney and Councillor Justin Tamihana, on my left, Councillor Sam Jennings and Councillor Piri Here Tukapua. Could I also acknowledge the officers present today, and thank you for the work you've done to date and the work that you'll be doing today to help us through the process. Acknowledging also others in the public gallery and anyone watching online. Moving through the procedural part, apologies, there are none, we're all here. Late items, no late items. Any declarations of interest? There appear to be none. Is someone happy to move confirmation of the minutes for the 5th of December 2023? Councillor Jennings moves, Councillor Tukapua seconds. Those in favour, please say aye. Against, say no. It is carried. Thank you. So just talking now about the process that we'll follow. I want to move through a fairly structured process. So first of all, I'll just invite an officer overview from Vi and a chance for question and answers just at that higher level through the overview process. Then we'll call on submitters just to alert you that you have 5 minutes to speak, and if you wish to allow time for questions, you might want to try and keep your points brief. We have read your submissions. You may of course wish to highlight points that you want to make, but there is the opportunity if you want to have questions also. Following on from that, we will get the officer response or officer's response to those submissions, and there will also be an opportunity for question and answers of the officers. We then move into deliberations, and we will move through the recommendations page by page. Opportunity also, panel members, for further questions of officers as we move through those recommendations. So with that in mind, I think I've covered everything. Yes, with that in mind, Vi, would you like to maybe...
James is going to
James. Okay, over to James. We're addressing the first draft bylaw, which is the Draft Land Transport Bylaw. Welcome, James.
Thank you, Councillor Allen. So I'm introducing the Land Transport Draft Bylaw. To give you a quick summary of the intention of the bylaw. The bylaw was due for review, so we legally have to undertake this process to keep our bylaw operational. The most significant changes which we highlighted in the consultation were addition of provisions and controls related to shared pathways, changes to reflect the recent or changes to the way we've been managing pay-by-space parking and pay-by-plate parking in our parking machines, prohibiting parking on the boom, which was a key change for this bylaw. We've made some changes to the process for permissions for roadside fence encroachments and roadside grazing applications. Operationally, the process hasn't significantly changed. It's more a procedural change for that one, where we're taking the details out of the bylaw and putting it into an application process. And changes to the schedules of parking with some new time-limited parking areas in the district, and capturing minor changes that have happened over the years, such as installing new mobility car parks, or new no stopping lines, or that sort of minor change. There were 11 submissions received for the consultation on the Land Transport Bylaw. summarised them in the report. Primarily, there were comments focusing on the shared pathways, with submissions requesting or suggesting alterations to permit horse riders or equestrian use. Parking on the booms, we had a number of submitters, 7 submitters. There was a lot of discussion here from the submitters around the either opposing or I suppose a conditional support in terms of wanting something that's not a blanket approach to parking on booms, where there could be reasonable exceptions. I'll just briefly talk about that particular point, if I may. The parking on booms is administratively looks like a blanket ban. The intention of officers is to have that bylaw and enforce when needed, and have the enforcement officers' discretion very much play a role in the enforcement of this bylaw. The intention is not to prevent parking on every single boom. There's parts of the district where parking on boom would not be a problem when that's happening occasionally, when it's not causing damage to infrastructure. It would be an administratively extremely burdensome process to schedule out a bylaw where we work out which parts of the entire district's booms are okay to park on and which parts aren't. So the intention here is to leave it up to the enforcement officers to assess each particular situation. And that's really the bulk of the discussion I had on the Land Transport Bylaw, and I'm happy to take any questions.
Thank you. And before we do that, apologies, I got a bit out of sequence. Could I take you to page 8, recommendations A, B, and C, which are receipt of the submissions, that the matter is recognised as not significant in terms of the Local Government Act, and C, which is that the committee considers feedbacks from the submitters and officers on the draft Land Transport Bylaw. Someone prepared to move those in block? Thank you. Councillor Jennings moves. Councillor Tamihana seconds. In favour, please say aye. Against, say no. It is carried. Thank you, and apologies for that lack of sequence there. Questions for James from the panel? Mayor Burney?
James, in terms of booms, the commentary was around those areas that don't have full footpaths or the boom concrete sort of. Do we need to differentiate between those sorts of things?
In my view, it's the most efficient approach is to differentiate at an enforcement officer's level. It would be difficult to have a consistent definition of a curb within a district. There's lots of different sort of interfaces between a carriageway and a boom. Really, we would take a common sense approach to the enforcement, and the regulatory and compliance team have a fairly robust process for these enforcement activities. It's not a situation where someone parks on the boom and they're getting a ticket 30 seconds later. There's a process of education, warnings, etc. before it becomes an enforcement situation.
And I'll be interested in the comments from Mr. Eccles from Wairuri later in terms of the impact that I would imagine there's probably quite a few residents, even over the summer, especially when there's the population is greater, where they do park on the grass off the road because there's not enough room to park on the road, and so that would be not that would be a usual occurrence rather than an unusual occurrence.
Just aware too that we will come back with questions to James, and we've heard from submitters. So with the indulgence of the committee, I think we'll move into the submitters now. We have 5 who are going to speak to this particular proposed bylaw. Submitters 1, 2, 3, 4, and 5, and we'll invite William Walsh if he would like to come to the table, please. Oh, William's not here. Okay. We have Sam Jennings. Sam Ferguson, sorry, too much courtesy there. Sam Ferguson, who's joining us via Zoom. Welcome, Sam. Can you hear us?
Kia ora. Yes, I can hear you. Can you hear me?
Yep. Go ahead.
Right. Yep. Morning, everyone. So just to be clear, this is a personal submission. It's not a Horizon submission, and I'm not entirely sure who's on this committee, but it's good to be able to speak with you. So there was 2 areas I wanted to cover in my submission, and these are obviously both in writing, but I wanted to just comment on 32.1, and so it's just around the bus stop process and the bus shelter process, and I just encourage you to think about a process of consulting, notifying and appealing when bus stops and bus shelters are being established within the community. Just seeing some challenges within Wanganui and Palmerston North, and the benefit of having that prepared in advance versus trying to prepare it, define a process and run the process at the same time. So that's some experience that I have seen in other communities. And then I wanted to talk also about the bylaw in relation to pedestrian access, and for those members that were around last term, you may recall I did speak to this council on exactly the same issue, and at the time I shared photos and the likes of vehicles blocking pedestrian access. And in our community, it is it's an ongoing issue. It's a daily occurrence, and so just reminding us that we have a significant aged population in our community, but we also have families and children, and these are the people that are impacted when our footpaths are blocked. Elderly, if they're on a mobility scooter, they may not be able to get around a vehicle. Even if the vehicle is partially blocking a footpath, mobility scooters are quite wide, they may not be able to get around at all. So that's impeding their access. And then if there's a mum or dad pushing a pram or a stroller, getting around a vehicle is difficult, and also for people with any level of disability. So like you think about in winter, trying to get around a vehicle, perhaps having to go over a muddy berm or other situations, or go onto a busy road. So it's avoidable. And the reason I bring this up is, sure, you can put in place your bylaw, and you've already got some of the laws around this, but it's the enforcement. And I'll just compare, so this council also does enforcement of vehicle registrations and warrants. And a few years ago, I asked the council how many infringement notices have been issued for registration and warrant breaches versus parking on footpaths. And the figure was almost 2,000 tickets in 1 year for registration and warrant breaches, and 5 tickets for parking on footpaths. So for me, that's a prioritisation. You as a council have the ability to put more resources into this, and obviously the government have just increased their the fines that can be applied. So yeah, my encouragement, my challenge to you is to look at how you can more proactively apply your discretion and education, and moving towards changing that behaviour of people leaving their private property on public walkways and footpaths. So thank you for your time. That's my submission.
Thank you, Sam. Any questions? Councillor Jennings.
Hi, Sam. It's the other Sam here. Hey, I don't know if you've had a chance to see the officer response and recommendation to your submission, but in summary, essentially the gist is that officers are saying that in terms of your commentary, that's more about our enforcement approach as opposed to the wording or the contents of the bylaw. And I just wanted to get your response to that summary, because I tend to agree with the officer summary that what you're talking about is how we would enforce or how we would apply the bylaw rather than the mechanics of the bylaw itself. Do you want to respond to that?
Yeah, for sure. So no, that response hadn't been provided to me, unfortunately. I guess I would say, in just based on Mayor Burney's question just previously around parking on berms and how that's enforced, it ties together. So you as a council can make decisions around prioritisation of operational activities and a proactive approach to enforcement. And I heard the words earlier: discretion, education, warnings. But that's an approach that this council could choose to take. And I agree, it's separate from the wording of the bylaw, but it's a direct result of the bylaw enables you to do that. And what's the point of having a fantastic bylaw if it's not able to be enforced in any way?
Thank you, and I'm just aware of time, so thank you for your submission, Sam. Much appreciated. We're calling now on Carol Dyer. Welcome, Carol.
I'm not sure of the
Right-hand button. That's it, you're on.
I think I've got a loud enough voice that probably you'd hear me regardless. I'm not sure of the...
Sorry to interrupt, Councillor.
Apologies, Chair. I should have said at the beginning I won't comment or question in this particular submission because it mentions local whānau ora, which I'm a board member for. So
Thank you. So just for clarification, Councillor Tukapura has declared an interest in this particular item. Thank you. Back to you, Carol.
And I appreciate that. It's a very, well, for me, a very difficult situation because I don't want to get offside with our neighbours, and that's what I have put in my submission. I am interested to know that the photos that I attach with my submission are not with it. So I don't know whether you have seen it. And this summarises the problems on several days that we have had. So basically, having taken the time to put together a submission on the parking issues which face us as residents of Bath Street, I appreciate the officer comments about the inconsistent monitoring of the parking. I have actually read the updated report. But any idea of employing another enforcement warden or parking warden is dismissed because of the financial constraints. This does not take into consideration that increased payment of fines could help to pay for this person. I feel rather miffed that the safety issue in exiting our property because of inconsiderate people who park all day in a 120 restricted area is not considered worth mentioning by the officer comment, except to point out that this is an operational matter under the compliance and enforcement policy. So I've commented on the photos. I will put in there, and I've already spoken to Vaimoana about Shana and Hayley, who have come up at various times to monitor the parking. I have no idea whether tickets are issued or just a letter or what, but I object to people parking right outside our place all day, making it very difficult to exit our property. I've commented about the photos. These clearly show the problems we have with compromised visibility between our property and Parker Avenue. Safety for Horowhenua citizens should be given a much higher priority than currently appears to be the case. The simplest option of dashed yellow lines painted between our drive and the exit of 152 would solve all the problems we face with the parking, but this has not been considered. It's very easy to just leave the rules as they are, but this results in very dissatisfied, disgruntled residents whose attitude to council dealing becomes perhaps rather negative rather than positive. And I've had previous dealings with various members of council, and I do try to be positive, but I'm really upset about this going on for the last, well, actually since 2021 there's been a problem, and while it has improved, it is still not in consideration of us trying to exit. We come out of our driveway and try to pull it in to what would be the parking level along, and sometimes it's just impossible. So we have to go out onto the main road. We risk being tooted at. We risk people coming down Bath Street and swinging out round us, and there is a row of parked vehicles on the other side, which is unrestricted, and they're there all day as well. And very often they restrict the access for residents opposite. But okay, that concerns me because often the ambulance comes to one of them in particular who's a very ill man. So basically, are there any questions?
Thank you. Are there any questions of Carol? Councillor Tamiha.
Tēnā koe, Mrs. Dyer. Thank you for your submission and thank you for raising them. Not so much a comment, but I just wanted a question, but more a comment to thank you for the detail and some of the recommendations you've given to us to consider. I think they're actually well thought out, and definitely something for us to consider as we make our decision around this.
Right, thank you. The yellow lines, there are several properties east of us who have yellow lines outside their properties. I don't know why, unless it's something to do with the schools and parking for the schools. I noticed yesterday, actually, that the KBC, is it, just above the roundabout, there are yellow lines out there, so people can't park for the physiotherapy clinic. I don't know why. Is it a real expense to be able to put yellow lines just between us and the next exit? The suggestions I made obviously range from the simplest to the most expensive, and cameras are expensive, the operation of them is expensive, the monitoring of them is expensive because you need to pay somebody to go through them. I appreciate that.
Carol, thank you for your submission.
Yellow lines, please.
Yeah, and look, we do appreciate the reality of the stress that you're feeling as a result of that.
Okay. The other thing I just would like to point out is that I went right through. I had great difficulty understanding some of this. I'm just an ordinary person, really, but I think I'm reasonably intelligent and articulate. I wrote a letter which was handed in to the office here, and I've never had a reply or anything about suggestions in which this could be improved. Where are the maps? There aren't any. And I think
Thank
operations
you,
people need to look at that.
Thank you, Carol. And for your submission. Bruce Eccles, welcome. Just to note before Bruce speaks, the photos that Carol referred to have been emailed to all panel members, so you'll see that as part of your file. Thank you, Bruce.
Morning, Mr. Chairman and Committee. Thank you for listening to the submissions from Waitariri Beach Progressive and Ratepayers Association. Obviously, this affects a lot of Waitariri, what we're currently discussing. We went through all your proposals, and most of it we fairly well agree with. But we get down into clause 5.1 on the definition of a burn, which becomes a real problem for us at Waitariri, because the way we read your current definition, it means that the berm commences at the edge of the paving, the asphalt paving, whatever it is. Well, that might be fine in streets that are that have curbs and established footpaths, but at Waitariri we still have many streets, particularly busy streets, that have no curb, no channeling, and no footpaths. And in some of these cases, these streets are less than 5 metres wide. So if you park an average vehicle of 1.5 to 1.7 metres wide on each side of the road, as is allowed, there's very little room for anybody to get down the middle. So we thought a better definition of the berm may read as something as follows. It means a path or grass strip beyond the identifying curb or channel or paved footpath until the boundary of a private property, which means in the situations where we have at the beach where there is no footpath or no curb, I guess you can park right to the front of the boundary fence, which people do. In cases where there is a curb only, that indicates from the curb to the boundary is a berm, and it's treated as such, so there's no parking on it. Where we have only a footpath, the area inside the footpath to the boundary of the property is regarded as a berm, hence no parking. I mean, we have constant cases where people park willy-nilly all over the place. We need to tidy it up, and we accept that. I mean, come the summertime, you'll find every bit of grass nearly outside any property gets parked all over, which is a pity now, particularly that residents are now required to maintain berms. The last thing they want is to have cars parked all over it. But I think the strip of grass between the edge of the asphalt and the curb, or the piece of grass between the end of the asphalt and the footpath, should be available for parking. So that's our submission on that. My question about it is even if we go ahead and you introduce these bylaws, what are you going to do to police it? Because it's all very well having a bylaw, and we tell our residents that there is no parking on the bit of grass between their footpath and their fence, but somebody comes and parks there. What are we going to do about it? I mean, it is rapidly rules out there, particularly at the summertime. We do need, if we are to introduce these bylaws, they need to be policed. So I just leave that with that one. Okay. Now, are we also doing the proposed amendments for the public places?
Are you able to stay later for that, Bruce? How flexible are you?
What time? I mean, they've given me one time to submit.
Yes, I'm just aware that we haven't actually received any of that documentation or had an officer overview. So,
okay,
if you're flexible, I'd prefer to leave it.
Yep. No, that's fine.
Is that okay?
As long as I get notified of another time, that'll be fine.
Yep, and we'll let you know.
Okay, yeah,
as accurately as we can. Yep.
Okay.
Thank you, Bruce.
Right.
Before you go, are there any questions? Okay, appear to be none. Thanks, Bruce, for that.
Thanks.
And call now on Richard Smith.
Thank you, committee, for allowing me to speak. I made submissions on two issues. One was the shared pathways paragraphs, and the second one was on vulnerable road users. If I could start with the shared pathways. At the moment, the legislation does not allow for any multi-use pathways. It says shared pathways are the one thing that it does allow. And we are talking in Foxton about the potential of a multi-use pathway around the target reserve. Now, your current legislation wouldn't allow that. So the suggestion I put into the bylaw was not to force council down any road in terms of saying we must have shared pathways, but it does allow council to make that decision in the future. I want to make that quite clear. I wasn't suggesting any specific multi-use pathway. The reason, and what I want to speak to now, is really the council response. And I'm getting very disappointed with council response on this issue. The reasoning, the response was no. We're not doing that. We don't believe in multi-use pathways. And the reason they gave was surface damage, hygiene, and enjoyment of all users. Surface damage, horses do not create surface damage on main pathways. I've got a letter from Kapiti Coast District Council which reviews that issue. I'm happy to share that with the committee. Hygiene, horses' poos, or whatever you want to call them, are just grass. And if horse riders are as responsible as dog owners and deal with it by at least kicking it off the pathway and into the grass area, then there's not an issue in terms of hygiene. Remember, a horse excrement is grass. It's not like a dog excrement. Thirdly, enjoyment of all users. Well, not all users, because you've restricted the users. You've taken horse riders out of the equation. And I'd like to ask the council, what evidence have you got for these three issues? What research have you done to find out about these issues? And have you done a user survey? Have you checked with the other users to see what they feel about moving to a multi-use pathway? Harford District Council, I feel, is out of sync with what's happening around the country. Ignorance of these trends is not an excuse. You've got three areas adjacent to you: Kapiti Coast District Council, Horizon Regional Council, and Greater Wellington Council. All have multi-use pathways. Has anybody gone and talked to these organizations? All the years we've been promoting multi-use pathways in Harford, we've told council about these three organizations. Has anybody from council, any council member or council staff member, gone and talked to any of those organizations? I'm offering to take you down. Matter of fact, you can even ride my horse on one of the multi-use pathways if you like. I've got an old mare that I'm sure will cope with it. I'd like you to experience what it's like to be on a multi-use pathway. And that's what I'm asking council to start looking into these things rather than making arbitrary decisions based on previous distinctions.
Just aware of this, you've got about a minute left, just
Okay.
so you're aware of that.
The second issue is vulnerable road users. I made a submission on this. I saw no council comment on it, so I guess it's approved, is it? Council didn't make a comment. There's no staff comment. This is a major thing that's going on. There's a petition going to Parliament in next week, which has got over 6,000 signatures. There was 50 horse rides around the country promoting this. I wanted to show a video today, but I was not allowed. The people that are running this petition have approached numerous organizations, including 7 of the 9 regional committees, transport committees, and they have approved, or they have sent letters to Parliament. The Ruapeo District Council, the Hawke's Bay Regional Council, Cycling Action Network, Ashburton District Council, Greater Wellington Council, New Zealand Police, Automobile Association, Riding for Disabled.
Your time
All
is.
these are supporting that thing, and you couldn't even make a comment.
Thank you. Your time is up, but I'll allow if there's one question maybe. Mayor Burney has a question.
Just a comment, just to assure Richard that the Regional Transport Committee is relooking at the vulnerable use for and advocating on behalf of horse riders in that space. The letter was just being circulated and drafted at the moment to put that advocacy to the government on your behalf.
Yeah, I heard that the mayor from Palmerston North was not very happy.
Oh, look, it's
No,
just
thank you. Mayor Burney's made his comment, and thank you for your submission. So we now move to the agenda itself, and on page 9, we start with the recommendations there. So the first recommendation is around the shared pathways, and the recommendation is that we retain the current shared pathway provisions, including horse riding, to ensure safety, cleanliness and enjoyment for all users. Does anyone wish to speak to that recommendation or have any further questions of officers on that one? Councillor Jennings?
Yeah, I just had a question for officers, and I probably should have directed it to the last submitter, but we have had submissions about this in the past, and the issue of horse poo is a live one, and I've heard the equestrian responses to that topic before, and for me, I don't accept the response, but I'm just wondering through the officer assessment of the submissions in this particular topic, have we looked at other places where there could be a requirement to include like a poo collection bag? You know, like I've seen them before where they have it behind the animal, and would that go some way to potentially? So the question is, have we considered that, and is there some scope to potentially look at whether we could have some flexibility in here if that was a feature that was required?
Thank you for the question, Councillor Jennings. Officers have not investigated that potential solution, but we can go away and do some homework on that.
Any further questions? Okay. Question, Councillor?
Yeah, I do have one. And I think I've asked it before about, because we're using the word all here, and all is not really what we're reflecting here around equestrians. And so I've asked officers before about where are those identifiable areas in the district that they can use, and I don't think I've seen that come through yet. So just for me, I'd like to understand where is there space in our district, and I think we need to ensure that there is a space for them in this district. So that's all I wanted to comment. Sorry.
Did you wish to comment on that, James?
Thanks for the question, Councillor Tamihana. I believe it's a piece of ongoing work which myself and the land transport team and my colleague from the Parks and Property team are developing plans in that space. We're probably not in a good position to come back to you with the level of detail you're after today, but we can take an action to go away and develop that further.
So we'll note that, but also note that question does lie outside of the actual considerations of the bylaw at this stage. That's a wider issue. So there is a recommendation there. It's a recommendation only. I'm in the hands of the panel.
Yeah, so
Councillor Jennings.
Thank you. Yeah, look, comfortable with the scope of the recommendation. I just wonder if we should change that word for all existing users, because as the last submitter did point out, it's it's not enjoyment for all users because there is one user group that's essentially excluded at the moment. So so that would be my suggestion, that enjoyment for all existing users. And then I don't know what your comfort level is in terms of perhaps just an action which is for us to, and I don't think it's a significant priority, but to investigate with other territorial authorities their approach to horse droppings and that kind of stuff. So, because I just want some further work or some further looking at that particular issue before this came back to the table.
So in terms of the business of today, it's if I understand you correctly, Councillor Jennings, you are moving the recommendation with the insertion of the word existing prior to users. And if we perhaps deal with that first and then the wider one, is there a seconder for that recommendation as it stands? Mayor Burney seconds. Open for discussion. Councillor Jennings has spoken already. Anyone else wish to speak? Otherwise, I'm going to move on.
I suppose for me, Councillor Allen, it's the wording of the excluding of horse riding that I'm struggling with, and I'm worried that if we pursue the clause the way that it is, that it's actually already giving a signal of a decision, and so that's my concern. I'm just raising it as a concern. I'm just trusting in the process and the action that we've signalled today. But that's for me is a genuine concern that wording could impact negatively later in my thinking.
Thank you. Further discussion, Mayor Burney?
Maybe a question for Vi. I mean, this is the last time we reviewed this policy was 2017. So if we put it in the new policy at 2024, excluding, how difficult is it to return to a bylaw if it's not within that 6 years or 8 years that it needs to be?
The process to go through for amending a bylaw is essentially the same as going through to develop a new bylaw. It would go through the public consultation process. We would receive submissions. We would go through a hearings process, not much similar to this, before the changes were adopted, again through council. If the changes were, in this context, it would require some significant changes to the current bylaw, and so it would need to go through a full consultation process.
Any further speakers before the right of reply? Councillor Tukapua, I think.
Yeah, picking up on the point that Councillor Tamihana raised earlier around where can the equestrian riders go, or the horse riders go, there's work being undertaken now for Target Reserve, but then there used to be Cousins Reserve, and there are maybe one or two other places, but there are only a few, and then there's racecourses and farms. But I would be prepared to support the recommendation with the added word existing if there was to be later provisions made under, I guess, what the submitter outlines as our general parks and reserves policy, where we could specifically identify 3 or 4 parks like Target Reserve as locations for them. Like if that's a piece of work that can happen, and then I'm happy to just go with the recommendation. I just need some reassurance or some confirmation.
Thank you. Right of reply, Councillor Jennings.
Thank you, Deputy Mayor. Yeah, look, I think that the recommendation is appropriate given. I think it is fair to say there's quite a significant misalignment between the equestrian community's expectations and aspirations and where council is in terms of its prioritisation and its focus on meeting those needs and expectations. And I don't think that the bylaw is the place to try and tackle that today. Like, I think there's some other initiatives that Councillor Tukupu has kind of highlighted. One of those things that we could work on to perhaps address that. But in terms of the bylaw, I think that the recommendation is appropriate based on the comments that others have made, and that we shouldn't try to do anything beyond what we're doing at the moment, because it needs some further work, it needs some further thinking, it needs some further analysis. So I think that it's entirely appropriate that this is where we should land today.
Thank you. I'm now going to put the motion. Those in favour, please say aye. Those against, it is carried. Thank you for that. And I just wonder, in terms of process, there have been a number of points identified about further work by 3 members of the committee. Is it okay just to note those and follow it up without a formal recommendation? But I'm seeing some noddings of head. So thank you for that. Moving now, councillors, to bottom of page 9. So this is around the parking on booms. The recommendation which sits there is clause 23, to retain the proposed boom parking ban with possible exceptions for specific areas, while investing in alternative parking solutions for high demand areas.
Sorry, Deputy Mayor, you said areas?
High demand areas is the wording.
Oh, you said possible exceptions for specific events?
Oh, I beg your pardon. Oh, specific events. I beg your pardon. Sorry. Thank you for that correction. So just so we're clear, for members of the public, retain proposed boom parking ban with possible exceptions for specific events, while investing in alternative parking solutions for high demand areas. Is there someone prepared to move that? Councillor Jennings?
Thank you, Deputy Mayor. Yeah, look, I'd be happy to move that, but I actually liked your suggestion with the change with possible exceptions for specific events and areas, while investing in alternative parking solutions for high demand areas. Because I think that there's an interim period where there may need to be some exceptions made, and we've heard from the Waitangi Beach community as an example. So that, yeah, with that change, that's how I do that.
I did have a question in terms of what do we regard as high demand areas? I mean, is it more than one car parking on a boom, or is it, yeah. But I'm happy also to support what Councillor Jennings is recommending. That I think there does need to be possible exceptions to it, so I'm comfortable with that.
Yeah, I'm probably not so comfortable with it, to be honest. I would like to have been able to have some data provided to me about what type of damage has occurred on our booms that makes us want to create such a bylaw. I'm more interested in, through you, Chair Tavai, perhaps asking, could there not have been consideration to a process by where a boom parking matter is raised with council, there is a notification to the vehicle owner, because sometimes the vehicle doesn't belong to the home or the house, and then for me it was more about what data do we have about damage that's occurred on our infrastructure on any booms in my district. I'm really interested to know what that looks like, because I'm more about not blanketing everyone with such a rule when it's an exception, I believe, of particular people that abuse the right of parking on a boom. So what I'm really saying is, if you find a site that a heavy logging truck or a heavy vehicle or something's parked on a boom and damaging our infrastructure, then for me, the process should be to engage that person directly, and we recover any cost of damage through those people. Because I think it's an individual choice. I don't think it's a blanket decision across this district with the types of booms and corridors we have throughout our towns. So that's probably for me why what I'm more interested in. Could the bylaw not actually reflect the individuals that abuse the right to use booms and cause damage, proven damage, to recover costs? That's the type of bylaw I'm more interested in than a blanket one. Because I'm going to be completely honest here. When I heard Councillor Jennings even say looking at parking solutions for high need areas, there isn't space in those areas. I'm very aware of my parks and reserves and rugby grounds and all those things around our district. There is no solution. We quite openly open our booms and our streets and our corridors and our towns to allow people to park. We see it every day, every week at Playford Park, where there's not enough room for Saturday morning rugby, but homes allow you to park on their booms and in their drives. So I'm more interested in, can this be rescoped completely? I don't like the wording in its current form.
So who was that? Would that be James? Who's going to answer that, James or I?
I might start and then may refer to James. The intention with the provisions that are in the bylaw isn't to change our current approach to compliance and enforcement. So our current approach to compliance and enforcement is to first work with the alleged non-compliant party, work through the process of trying to gain their compliance before moving through and utilising the tools that are in such a thing like the bylaw to allow us to prohibit inaction or parking on the boom that might create some damage. The intent isn't to use the bylaw to then go out there and proactively tell people they can't be parking on their boom. It's to enable us to be able to, where it is creating damage or it is creating a nuisance of some sort, actually having a tool to enable us to stop it. The absence of having a provision in the bylaw would mean that yes, we could still work with a person, but should they choose not to do anything about it, we don't have any instrument to go back to actually enforce, to have them removed.
I appreciate that, and I just hope that it's captured as well as you explained it, because I think community need confidence that this isn't a policing matter. It's not a revenue gathering matter. It's actually a genuine matter of how you can act and respond when a matter genuinely arises around our booms. But I'm just citing, I'm concerned about the blanket model that's been proposed.
Councillor Tukapa.
Yeah, I seconded the motion, but following that, Mayor Burney made a point that I'm quite interested in, and that's the definition of high demand. And then moreover, given that is about investing rather than first investigating, I'm a little uncomfortable, but I'm just flagging that before we go to a vote. Unless there was another speaker who could, make me comfortable about what the outcome of that really means.
Only observation I'd make, and actually back in history, there was a bylaw that did address the issue of parking on booms and did prohibit parking on booms. And the point of it, I don't know why it got repealed, but it did over time. And the thrust of that was about having an enabling provision which was treated with caution and common sense by officers, and if it was not, we would hear about it from the public. So the point I'd make from a personal point of view is that this is about enabling where circumstances arrive, that there is a power through a bylaw to act. So that would be my only comment. I'm aware of the pressure of time, so who moved that, Sam? Right, a reply, Sam? Councillor Jennings.
In the interest of time,
Okay, I think we will put it to the vote then. So there's the proposal with the addition of the word "and areas." Those in favour, please say aye. Those against, and acknowledge Councillor Tamihana's vote against. So that is carried. Now look, I'm aware that we're under pressure of time and there are a number of submitters waiting very patiently. Could I just get a show of hands, those submitters who are under time pressure? Yes, some are. So look, what I'm going to do with the leave of the panel is I'm actually going to receive the second one, the public Places Bylaw. I'm going to receive that, hear from the submitters who wish to speak to it, and then we will revert back to where we were at. I'm sorry, that's a bit messy, but I do respect the fact that submitters are under some pressure. So could we now pause and move to page 22 of the agenda? We're now on the Public Places Bylaw, and could I ask that if someone's prepared to move in block the receipt of the submissions, that the matter is deemed as not significant in terms of the Local Government Act, and thirdly, that we consider the feedback from all submitters. Someone move that. Councillor Tukapua moves. Councillor Jennings seconds. Those in favour, please. So I can say no, it's carried. And could we welcome back Bruce Eccles? Bruce, where are you? Is Bruce here still? No. Perhaps we could contact him, Alice. I think he was, if we have the details, maybe let him know that he's welcome to return. So with that in mind, could I just also identify a shift in who is speaking when? So we'll start with Donna because she gets most time. Oh, okay, yes. So Donna, would you like to join us, please? Donna Bright. We're moving around a little with the order here. Thank you, Donna.
Thank you. This looks like it's on. Okay, my name's Donna. I live at Waikawa Beach. I've been there for 28 years and I'm a horse rider. I wanted to speak to Bylaw 14 that covers access to the beach. In most cases, access to the beach is only through council land. So by restricting us as horse riders, it means we can't get to our only riding place. I want to make this quite clear. The beach is the only riding place in the whole of the Horowhenua at the moment. So by restricting us, we can't get onto our only riding place. That means I've got to put my horse in a float and drive down to Otaki, to another area, to Kapiti, or the nearest other one would be Hokio, when I live 2 streets from the beach. I also want to speak in support of my neighbours who are fishing people who currently can't get down to fish. So most of us brought out at Waikawa so that we could enjoy the beach. Now, I understand that what you're trying to prevent is people hooning around, running over people, running over the birds, etc. These are people who've got tractors who just want to launch a boat and enjoy their hobby like I want to enjoy my hobby. And I am concerned about blanket rules that stop us from doing things. 14.2, 14.3. Yeah.
Thank you. Points well made. Questions of Donna?
Deputy Mayor.
Yes.
So I had a question about the section of the bylaw, but did you want me to park that now so we can just continue to hear the submissions? Yeah, sure. So my question, and I sent an email in advance of the hearing as well, is that I was a little bit concerned about the wording of the recommendation, and I wanted clarity around the scope of the bylaw and whether it imposes additional restrictions that are currently in place right now, or whether it simply provides the tools to provide restrictions later should they be required. Because I think it's what I would like is clarity for the public and for elected members around, are we changing anything in terms of the status quo, or are we just giving ourselves tools to be able to respond to antisocial behaviour or other problems that we might see? And I think that would be useful to get that clarity, if that's okay.
Thank you, Councillor Jennings. To answer that, the intent of the provisions in this proposed bylaw isn't to stop access to the beach, isn't to prohibit, isn't to wildly prohibit the activities that we know already are currently happening. What it does do, as you rightly say, is it provides us with a tool to, when needed, to carry out compliance and enforcement activity that might stop antisocial behaviour, might stop damage happening, unsafe practices. And so it's not to prohibit the access, but more to introduce a level of control over, in some aspects of the provisions there, it's about where you can access the beach and activities in the dunes.
Can I just have one follow-up question? And so the submitter has raised a good point in terms of, so there's nothing in the bylaw at the moment that says she would be prevented from taking her horse. If this bylaw proceeds, there's nothing at the moment in the bylaw that says she would be prevented from taking her horse onto the beach unless council made a determination and used the bylaw to restrict that access. And would you anticipate that there would be a separate process or a separate consultation with the community if there was an intention to have some sort of more blanket restriction or access control?
Yes, so the intention isn't to prohibit what is already happening at the moment. Those access routes are still those access routes. What we do need, though, is some control over when you are potentially using those access routes but creating damage, or some of the way in which they are being used. There is a reason for enforcement officers to want to restrict that activity. So that's what the intent behind those provisions are for. We currently don't have any.
Can I make a further comment? Horses are already restricted by a bylaw that forbids them blanket across any parks and reservations. So I've had to fight long and hard just to get onto the beach at all. Thank you to Lacey for helping me get a temporary access onto the beach. That runs out in November, I think, and I would like that to become a permanent situation. Otherwise, all horse riders who live in that area can't get to the beach at all.
Thank you for that. Thank you, Donna. All right.
Thank you.
Josephine Guthrie from the Cancer Society, Manawatu.
Sorry. All right. Kia ora koutou, ko Josephine toko ingoa, ko taku mahi tō te whenua. Thank you for the opportunity to speak on my submission for the Public Spaces Bylaw. The Cancer Society Manawatu holds a strong position advocating for smoke-free and vape-free environments to reduce the rate of smoking-related cancers within our communities, so that our places are where rangatahi and tamariki can grow up with fresh air and healthy choices. Being a smoke-free and vape-free community offers numerous benefits, including positive role modelling for our tamariki and rangatahi, healthy environments for families, protection for non-smokers and second-hand smoke, and reduced harm to the natural environment. The Cancer Society Manawatu fully supports the proposed Public Spaces Bylaw additions. Smoke-free and vape-free regulations into permit applications for events is an effective way to ensure more inclusivity and support to families, non-smokers, as well as those trying to quit smoking or vaping. This initiative has seen great success in Palmerston North City Council, creating more awareness around their smoke-free, vape-free environments policy, as well as positive feedback from attendees at these events. Prohibiting smoking and vaping in outdoor dining areas upholds the Council's Smoke-Free and Vape-Free Environments Policy 2022, while also providing safe and healthy environments for the community. In addition to this, having clear regulations around signage and display of the signage, as recommended in my submission, would aid in the enforcement of this bylaw, while also making it clear that enforcing the bylaw is a shared responsibility between businesses and the public, who must respect the signage. Research has shown that adequate promotion of smoke-free, vape-free signage and the promotion of policy provides the best results for deterring smoking behaviour in regards to outdoor dining spaces. We must also remember to support businesses within this initiative to enhance compliance. The Cancer Society Manawatu is willing to assist in the implementation of this bylaw and its additions in regard to smoke-free and vape-free environments. As one of the many stakeholders in the smoke-free and vape-free advocacy space, we strive to collaborate with other agencies to support positive outcomes for our communities. By aligning our efforts with ongoing developments in smoke-free, vape-free policies, bylaws, and enforcement strategies, we can drive meaningful change in smoking and vaping statistics, ultimately leading to fewer families facing cancer diagnosis. Thank you for your time.
Thank you for that. Any questions? appear to be none. Thank you very much for your submission. Sophie and Morris Campbell? Or perhaps just Sophie?
I pulled a short straw.
Welcome.
Thank you. So the first topic is about fireworks. We believe that council needs to prohibit fireworks and fires in public places unless a permit is granted. And in addition to that, we would like to see a total ban on all fireworks in this district, except for displays being handled by licensed professionals. The reason is every year the fire service deals with problems caused by fireworks, as do individual pet and animal owners. And when we have a dry summer, people are letting off fireworks, frightening horses and stock in nearby paddocks, stressing dogs and cats, and giving us all a stressful time because of the dry vegetation in the area, worrying that it's going to catch on fire, and also knowing that Waikawa Beach is 20 minutes from a fire service. So by the time they reach the beach, it's likely to have burnt down several houses. So hence, there's two bits to that. There's in public places, but there's also in the entire district. So another issue is that people buy the fireworks, then people visit the area, and then they let off the fireworks at different times of the year when no one's really aware if that's actually happening and have got animals inside. So that's always been an ongoing issue. The next one is Section 14 beaches. So it's kind of about the defining the designated access route. So when you say some of your words and you say access to the beach, which you've all been talking about today, I feel like you should define it whether it's vehicle access or pedestrian access. People think access and they think I can just drive there in a vehicle. We've had that situation at the beach. So if council aren't clear about that, then the ongoing issues are going to continue where people think they can just drive down that track. In item 14.2 it says a person must not drive any vehicle onto any beach except on an area which is set aside by council for that purpose. We believe that clause is ambiguous, and is it referring to accessing the beach or to driving on the beach? So that should be tightened up to make that clearer. The other thing was about beach access areas, which was in Schedule 3. So just kind of being more defined about when you say access areas, are you saying vehicle access areas, pedestrian access areas? Just make it clear for everyone to make it really obvious. So we feel that protecting the dunes is a now issue. It needs to be done by this generation to protect the fragile environment for the next generation and the next generation. So the rest of the world does seem to have grasped this concept. I've recently been in Sweden, Scotland and the Shetland Islands visiting beaches, forest areas and walking tracks. No one's driving in these areas. So the tracks are set aside for walking to beaches and forests. The other thing about the whole thing with vehicle access is not everyone can access every bit of New Zealand. So lots of members of our population cannot access a forest park. They can't access a ski field or a remote lake. They can't access some restaurants in Wellington. So, and the same does apply in the Horowhenua. So some beaches can be accessed by vehicles and some can't. So some people hike to the Tauras from Poes Road, up Mangahao, back of Shannon, but a whole lot of people can't do that. They can't get over the fence, they can't walk down the track. This doesn't mean that all public places in our region should be made to be accessed by people and vehicles. So we have vehicle access at the moment in the Horowhenua at 3 beaches, I believe, Hokio, Waitarere, Foxton. Boats can be launched at these beaches, people can drive their families onto these beaches. But Waikawa Beach does not have that facility now. So I just think you need to ask yourselves, does Waikawa Beach really need to have vehicle access onto it? So the vehicle access that has been there for about 50 years. So it's been through private land. So the private landowner has now said no more access through our land due to reasons probably to do with the environment as well. We all know there's a lot of erosion in that area. There is no other alternative. No one's been able to come up with one. So one of the other alternatives that people keep throwing around is on Ray Mackay we have 2 recreational reserves which are protected by the Reserves Act. So they're designated for that purpose, and these are walking tracks to the beach. So we have formed a group who we're working with Horizons Regional Council to protect those pedestrian walkways, to protect them as pedestrian walkways. This year we've been successful in getting funding for plants to improve and enhance the walkways, and we're planting, I've just been choosing all the plants, so that all the rare and endangered plants that occur there now, and we've gone through lists that we've got from scientific people. So what we want is
Sorry to interrupt, we're starting to get a bit tight on time.
Okay, last sentence. We want council to continue to support our work. So if you're going to start talking about putting vehicles down the tracks that we are planting and spending thousands of dollars on, that's not supporting what we're doing. So we're asking for some clarity in that.
Thank you, Sophie. Time for one quick question, if there's any burning question from councillors.
I actually have a couple, but more for officers. Thank you for your submission. I note in here we state we own the beach. So one, I want clarity from officers about who owns the beach. Two, I'm interested in who's legally responsible for the beach. Three, is it still a legal road corridor? And if it is, then who does that responsibility sit with? Four, I'm all for protecting our environment, and access is a privilege. I get that. But there's lots of people to consider. Hearing the submitter, I do get concerned that when we're exploring options as council about where and how we facilitate the needs of that particular community at place, I'm a little bit worried that when I hear they're working with Horizons and there's a planning strategy going on, that by doing such work potentially takes away an opportunity of an access site. So I'm going to say that publicly, because I am concerned that when we get so limited scope in areas we can potentially create an access that works, if we're turning it into a reserve and planting it up, then we're actually removing an option immediately. And I'm finding that I'm going to have no options I can actually help to make a decision on. So
am I allowed to comment?
That's my...
Sorry, this is getting a bit messy.
No, sorry, but I just have to
This
say
is a question, fine, but the question is starting to move into the area of debate as well. So
well, the question was for officers for some clarity, but I'm concerned by what I heard with the submitter, that potentially work that happens in that way through you, Mr. Chair, potentially removes an option for us later to consider, and that's my concern.
Okay.
Can I just add that that's a designated recreational reserve, so to remove that status has to go through government, has to go to the Ministry of the Environment, and the track is only 5 metres wide, so effectively using engineering principles, it's not actually wide enough to have as vehicular access because you've got to batter the banks. So that's why we're concentrating on that track.
Thank you, and that's fine. So look, we'll come back now to the questions for officers. There are quite a few of them. I hope you got them all. Who is going to be brave enough? James.
Thank you, Councillor Tamihana. So if I recall right, I'll do my best to cover the question of, I suppose, jurisdiction of the beaches. So it's legally a road in some ways, but not in other ways. It's not a road reserve. It's not a legal road reserve, but vehicles can access it, and vehicles that use the beach are expected to obey the road code. It's similar to a private car park in that the road code is still in effect and a speed limit can be in place, but it won't necessarily be a legal road reserve. In terms of who's in charge of the management of the beaches, there are a number of government agencies, for want of a better word, who have a hand in it. The Department of Conservation do a lot of work managing coastlines. The Regional Council has a hand in managing the foreshore. Our involvement is more around the public places aspect and its function as a road. I think those are the questions I can cover off.
Thank you, James. Just for clarity, so you said it's a legal road, but it's not a legal road. But yet people are fined and policed on the beach. So I just struggle with the clarity. That's all. Thank you.
Maybe I just answer. sorry, and just further to that, so under the Marine and Coastal Area Act, the council doesn't own the beach, and so you asked the question around we say we own it. We don't. But what we can do under that legislation is that we can introduce a bylaw to control and manage the area. And so what the Marine and Coastal Area Act says is that between the high water springs and the outer limits of the territorial sea is not owned by council, but council can have a bylaw to control the activities that happen in that space.
Thank you. Now, Bruce, you are welcome back again. Waitangi Progressive Association. Right, thanks for having me back. Again, we're discussing proposed amendments to the access to beaches, dunes, etc. The particular one is clause 13.3. And we suggest, in addition to the way the existing clause reads, to read, an exemption shall apply for authorised pest control, restoration, planting and pathway maintenance. Because of the way the existing reads, there is no access to the dunes area. That basically, other than the walkways and the designated roads, there is no movement to be on the dunes, which to pretty well we support. We don't really want all the public riding motorbikes, horses, walking even through the dunes. But the reason we want to be able to have access to it, we have a program working with Horizons on pest plant control in the area, and of course we need to move through that area first of all for the spraying programs that are occurring, and of course we want to move through the area with Horizons to see the effectiveness of the spraying. Remember, at Waitangi we pay a targeted rate to Horizons for the control of these pests, weeds. Each property is rated now $20 per annum, and as the representatives of the ratepayers of Waitangi, we want to be sure that we're getting value for money that we're spending on this particular program that is a targeted rate. So and as far as restoration of planting goes, we currently have working with the Ratepayers Association and ourselves and Horizons, we've planted now somewhere around about 2,500 plants, of native plants, back into the area in an effort to start trying to restore the dunes area to its original state. This work has been done under the guidance of a man by the name of Jim Darn, who is a specialist in dunes, and he's given us basically the history of the dunes and what the dunes look like prior to human interference, going right back. It's had a big effect. We are trying to plant that. So obviously we want to keep working in that. We've done this a little bit under the radar because the last thing we really want is everybody in the community to come and really, until we get our plants established and something happening, we don't want everybody trampling over the dunes to see what's happening. But we still want to be able to have access. But so we need to have it clear in the change of the bylaw that these activities can carry on. The other amendment is 14.5, where it's council may from time to time and for such periods as it deems fit, following public notification. So we've added the following public notification. Then it reads as the rest of the clause, but not restricting public thoroughfare. So basically that clause says that the council can close off the areas for events, whatever,
which includes, from the way we read it, to mean the beach in total. So it means that somebody can make an application to close off the beach for a private function. The council can grant consent for that, which would mean there would be no more. We need to maintain public access through the beach. The reason for that is our membership felt that if a beach was closed off for a private event, I might want to hold my wedding on the beach. They go through the process. I have the beach closed off. Somebody else wants to drive to their favourite fishing spot further down the beach. They're denied access to the beach. So we feel that amendment must include the wording "not to restrict public thoroughfare." And thank you. Any questions? Any questions?
No, there appear to be none. Thank you for your submission.
Thank you.
Richard Hammond. Welcome.
I am dyslexic, but can I give you a copy of what I'm going to say?
When you're ready, Richard.
Okay. This is on this submission of the Public Place Bylaw, Clause 14.2. The Hammond family have owned 32 Mangapara Street since 1976. The family was always down the beach in the summer. Dad taking us down the beach in the old farm tractor and trailer when we were kids. I used to take my kids down on a John Deere AMT. That's a all-material transporter. It's similar to a five-wheeler, but it has a deck on the back. And then I had a Polaris Ranger side by side. My parents are still alive, both 90 years old. I have a son that has highly special needs who will not walk a long distance. I live at Waikawa Beach full-time in Strathnaver. As my parents are older now, they cannot walk to the beach and they need vehicle access either at Strathnaver or in the village. I feel the HDC are discriminating against the elderly and the special needs. There are a few families in the village, and talking about all over the Horowhenua beach access, there would be quite a few families in the same situation in the village as the same situation. Yeah. They strongly feel no vehicle access would be a health and safety issue. A couple of weekends ago, there was a horse event at Waikawa where there was an accident and a helicopter was called. Under normal circumstances, this would have been dealt with the ground-based medical staff. Now, we all know that the ambulance has to authorise the helicopter pickup. I'm yet to find out if a ambulance crew would have been able to get through the Waituhu stream that is down by Otiki. Sorry if I haven't explained it the right way. To assist the patient. Good luck trying to get across the stream at high tide or in flood. Vehicle access is essential for Waikawa Beach. I like to say that. Well, why is the council here, like they're dragging their feet on trying to get us for us to actually get onto the beach, right, in this case. And recently there was a poll done by the Waikawa Beach Ratepayers Association via vehicle access, and the result was 70% of members wanted vehicle access, and there are far more people here than just those belonging to the WBRA. We have Fishing Club here at Waikawa with 56 members and growing, who are all desperate to get onto the beach, all at whom fully supports the Kirk Roman submission. Re the Purpose Public Place Bylaw 2024 and my submission today. Thank you.
Thank you, Richard. Are there any questions? Thank you, and it's fair to say this whole matter, regardless of the bylaw, has been subject to a number of workshops by council along with some public meetings. So your views are very much heard, and we'll take that into account. Thank you.
Thank you.
Cheers. Austin Mew. Welcome, Austin.
Thank you. I'm pro-business, pro-tourism, pro-families, pro-exercise, and I am anti-bureaucracy creating nanny states. I think the general public of New Zealand have expressed that view in the last government change. So I'm wondering why people have to come and get a permit to go down to the blooming beach. It's ridiculous. I want to know what's your definition of a public place? Anywhere that's not private. It's getting a bit nonsense, isn't it? It's one thing to say council specific place, or public building, public parks, or town boundaries or something like that, but you're trying to restrict people's travel, freedom of travel, in a free country. I think it's nonsense. What's your definition of nuisance, offensive behaviour, dangerous? We've got a police and we've got a legal system. We don't need any more people with more laws restricting anyone going on the beach. Nobody will come down here. You won't get any money from tourism or anything else. Half of these flipping bylaws need to be deleted, not expanded. You know, having a family taking their family to the beach and having a barbecue on the beach, they've got to give a permit? How stupid can you be? It's the safest place to have a fire in the world, on the beach. Stopping people exercising their horses and going around. This is nonsense. People not being able to go and have a fish to feed their family. It's moronic. And I think it needs to be seriously looked at. Most of these bylaws in here need to be seriously looked at. Stopping people from smoking in closed places, that's one thing, that's fair enough. But now you want to stop them doing it on the street? That's moronic. I'm not in favour of nanny states. It's communism. Thank you very much.
Maybe some questions, Austin. Any questions for Austin? Councillor Tamiya.
Thank you, Mr. Mayor, for your submission and the points that you raised. I suppose the only question I have for you, maybe to assist officers and council going forward, is do you see a space and a place to create a spatial plan that can facilitate everyone's needs that we can actually live with? Is there a way of doing this without, as you say, putting in bylaws that take away what we would consider people's free rights? How do you see us as a council being able to continue to advocate to let people use those spaces in such a way that keeps everyone safe, keeps everyone accessing the spaces? Is that a piece of work we're doing? Because what I'm hearing is you don't like any of it, but what's the answer here?
Well, I know there's a lot of good, keen, voluntary people. I've volunteered ripping out Old Man's Bed and so forth, and there's a lot of keen people that want to make the beach look beautiful. It's great, but the beach is controlled by the environment. It's not controlled by council. It's been hard enough for you to keep the sand off the car park at Foxton, but you put fences up in the sand dunes, and you can see about that much at the top of one or two of them. How much does that cost, putting a fence in a sand dune? That's pretty smart thinking. The signs, on the other hand, they're up in the air and they teach people about things, educating. That's good. And you can maybe educate people. But people want to go and play in the sand dunes and plant trees and weed the place. Good on them. But don't stop anyone else from going and walking around and enjoying themselves or riding their horse.
Okay, thank you, Austin. I think you made your views very clear. Thank you for that. Brett Russell. Welcome, Brett.
Thank you, David.
Hello.
Thank you for the opportunity to speak to you today on behalf of the Manawatu History Management Team's submission regarding the proposed Public Places Bylaw 2024. In our submission, we background what the team is all about, but I'd just like to say we are working out how we can better support the Manawatu Estuary, our unique Ramsar site, so that it can thrive and continue to be a world-class environment that we can all enjoy and be proud of. As part of that, we are preparing a new management plan to focus our energy in the right places in the next 10 years, to be launched hopefully in March of next year. And we're also taking the opportunity to update the Foxton Beach Coastal Reserves Management Plan. And in some ways, in response to Austin's good presentation, it appears that until the bylaw is duly enacted, there's nothing at present to legally prevent any folk from venturing into and being destructive of our dunes district-wide. And so we look forward to a quality completed bylaw. Just coming to some points in our submission, we recognise the purposes of the bylaw set out in section 3.1, but we'd also like to add a section E, because we feel it's imperative to include the additional environmental component, and so we suggest to protect natural geographic features and New Zealand native flora and fauna. And that's to enable due inclusion of essential environmental and biodiversity features. Just moving through our submission, under section 13.4, it reads as it states, I have had some reflection about the walking through within the sandy dune area. While there are fragile plants that hold our sand dunes together, and they can be easily destroyed, I don't know that it's generally a good idea to block off beach access unduly by restricting people walking through the dunes to get to the beach. And I think that needs to be tidied up somewhat to enable sensible walking through into the beach. And the other thing I'd like to talk about is driving along the beach. In Foxton Beach, it is deemed to be a road, but a biodiversity expert has informed me that the Foxton Beach as a road should only be the wet and sand between low and high tide marks to better protect the environment. And the other thing I'd like to talk about briefly is the penalty stipulation. I think it would be quite useful, though, under section 19, reference is made to the Act, which is presumed to be Local Government Act, but it might give the bylaw some more teeth if the actual penalties are stipulated within the bylaw. And apart from that, I think it's important to think about the education process, maybe through signs, or how council is going to promote the bylaw when it's duly enacted, and also enforcement. How is it going to be enforced, given our police have got so much on their plate with limited resources? Thank you.
Thank you. Any questions? That seems okay. Thank you for your submission.
Thank you very much.
Councillor Allen, I'm sorry, I've just realised something that I probably have to do what Councillor Tukapua did and declare that I've been a member of the MEMT Trust as well, and I should have noted that at the start. I do apologise. So just wanted to note that.
Thank you. That is noted. Thank you. Thank you, Brad.
Thank you so much.
Could we welcome now Grant Purdy?
Good morning. Thank you. My name's Grant Purdy. I'm representing the 63 clubs and 2,300 members of the New Zealand Four-Wheel Drive Association. Our credentials and our mana are well known in the Foxton Beach community and to council officers and several councillors through our volunteer work in that Foxton Beach area over the last 25 or so years. So I won't use up my brief 5 minutes going into that. People know about it, and it's now a submission. We strongly support the need for this bylaw, as indeed we've supported it since it was included in the current management plan, which is dated 2009, as action that there should be a bylaw to help manage vehicle damage in the Foxton Beach area, including the estuary. So not only do we support having the bylaw, we support having an emphasis on the protection of the natural environment and powers to better manage vehicles on the beach in relation to people's safety. And therefore, the bylaw brings the means of legally stopping people doing damage with their vehicles. We also strongly support establishing ongoing compliance measures. I've heard lots of comments this morning about bureaucracy and unintended consequences, but at the end of the day, there does need to be a power to actually deal with people who transgress and cause problems. So just our top key points rather than everything that's in our submission. I have to say that we've had a very positive and productive relationship with the council over the last 25 years or so. So it's a real exception for me today to be bringing up a negative point. So as we understand it, the papers for this meeting say that officers recommend councillors basically ignore all the submissions and accept option A, which is the bylaw as drafted. We're outraged at that recommendation. If nothing else, that draft bylaw is riddled with errors. And we believe it's also deficient in a few ways. So there's been quite a consistency of comment this morning from a number of submitters, which is great. We'd like to suggest that the bylaw has an extra bullet point in a couple of places. In section 3.1, we suggest adding protect the natural environment. And in 7.3, similarly, we'd like to suggest adding is likely to adversely impact the natural environment. And we're also recommending that in 7.3 we add clarity that failure to cease whatever behaviour is a breach of the bylaw and has consequences. So while a lawyer or an academic might say that some of these points are already self-evident in the bylaw or implied elsewhere, we'd say that they're really important points and need clear emphasis. So any repetition is a good thing. What do they say? Retention through repetition. A similar point raised by others is about walkers. Clause 14.3 says that walkers are not allowed in the sand dunes. We point out in our submission that walkers should be allowed in various places rather than prohibited. For example, that spit area south of the motor camp down to the mouth of the estuary has what is now known as the dune garden in it. that is a point of focus for a lot of people, not only to go in there as volunteers and help maintain it, but also help do planting, help clean up rubbish that's in there, or just go in there to enjoy the environment. And in fact, if you look at the new Foxton and Foxton Beach community plan that's currently being consulted on, it says that the Ramsar site and dune reserves are attractions for residents and walkers. Therefore, it's okay to walk in there, which is the opposite of what the bylaw says. Also, a point made by others in the past is about continuing to allow traditional vehicle access, like fishing and so forth, down the shore of the estuary and on the flat areas. That's allowed in the current coastal management plan. And when that was being put together, there was a huge public outcry when there was a threat to that access. And I suggest that will happen again unless the bylaw makes clear allowance for that traditional use. So, just to summarise, we strongly support implementing the bylaw, having made some corrections and improvements into it, and then we strongly recommend compliance with signs, fencing, monitoring, prosecution, and so forth.
Thank you, Grant. Any questions? Just a comment maybe from officers, those points of refinement, or maybe, for want of a better term, unintended consequences that Grant's identified, limitations on walkers, for example, and the continued ongoing use of the Mackenzie Trail. Could we just get clarification as to where the bylaw sits as worded on those issues?
Thank you, Deputy Mayor Allen. So the intention wasn't to restrict the current uses and permit process that we have in place for Mackenzie Trail, so to start there first. The walking, I think that was probably we possibly could have worded that better. And yeah, I think perhaps the committee could consider whether we made some amendments to the words that are in that clause of the bylaw. It certainly wasn't intended to stop the current activities, but more, as you rightly put it, Grant, provide us with the power to enable us to actually be able to deal with behaviours.
Thank you for that. No, thank you. Any further questions? Councillor Tamihana?
Yeah, not so much a question, more a comment. I really wanted to thank you for bringing those points to us and the clarity you sought through our officers on Vi. Thank you for that, because I was a little bit concerned too when I noted particularly no users able to use the dunes, and then around Mackenzie, and it's an area I know is highly used. So really, really great work, and just wanted to actually acknowledge the great work the 4x4 commit out in that area, and you've actually restricted your own use in areas, and you've done a whole lot of other things as a club, which has done nothing but support better use and actually supported the environment better. So I think that should be acknowledged as well, that you are huge contributors to positive change. Thank you.
Thank you, Grant. Catherine Lane.
Thank you.
Catherine, welcome. Or Calvin, is it? Is it Catherine or Calvin talking to us? I've got Catherine down here, but whoever.
Deputy Mayor.
You're a team.
Chair. Sorry, can I? Are you gonna? There are going to be more questions later, just around like that last submitter and the point you picked up on. That I heard the officer's response, but how do we actually deal with it to ensure that that is acted upon? Those amendments?
No, absolutely fair question. So in that process, there will be a time later where we can address any further questions to the officers. Yep. So that will be picked up. You're comfortable with that, Councillor Tukapua? You're comfortable with that process? Okay. Thank you. Calvin and Catherine, welcome.
Yep. Well, thank you, everybody. And just a simple kia ora, katoa. We have written out a submission, and we do come from a common environment, which is Foxton Beach, but more readily called Manawatu Heads. And as persons from the Manawatu Heads, we are especially concerned about the environment, and we have persons who have been down there just for a few years, and they will say how it is changing within their, let alone a lifetime. Now, the beach itself, I would that all of us read Te Hikianga or Te Wai Te Hikianga by the McDonald's or the McDonald's before they ever become a councillor or persons who put in a submission. Because I think the actual roadway to the beach and for transport areas, it was designated by the old provincial government to give a roadway for the Royal Mail to go from Whanganui down to Wellington. And so you're actually onto a government controlled, and that was definitely for convenience sake, it did give access right up to the hills on the basis of high tides. So it was really a governmental status of the roadways to the beach for the transportation of the Queen's Mail. But, however, our submission has said, I can't even read it.
You can't read it. Right. We were concerned with 14 point.
We'll just move the mic a bit closer to you.
We were concerned with point 14.3, which said that a person couldn't walk through. People have enjoyed walking through the dunes, and the walking doesn't disturb or damage the planting as does vehicles. So within the Manawatu Estuary, the Trust is concerned about preserving the dunes. A lot of effort has gone through into the planting, and we feel it's right that vehicles and other things are kept away from them. Is that right?
Yeah, no, that's correct.
Yep. You keep going.
Well, it is. We've had a lot of ratepayers' money invested in it, and a lot of locals' time has been down, and of course, council has been very supportive, and so you've got three councils. You've got the regional council, Department of Conservation, and of course our own Horowhenua District Council. But not only, if we look, when I was saying that the experience of persons who have been there, that the area has modified itself both geographically through erosion, and right the way down through the coast to Waitariri, that is a modified coastline now because of the pine plantation. But back to where we are at the actual Manawatu Head part of it, where does the sand go when it erodes off those sand dunes? It goes directly into the waters of the estuary itself. And then the estuary takes that water out and it goes to the sandbars just beyond the breaker line or within the breaker line of the waterway itself. And so those sandbars are actually building up. Now as the sandbars build up, therefore they are competing against the tide, or the tide is competing against the elevation of the sandbars. And if you have a 6 foot tide or a 9 foot tide at its max, which is a spring tide, there's less water coming over the bars than what came over 100 years ago.
I'm sorry to interrupt. I'm just aware you've got a minute to go,
Yes.
and there may be questions. So if you just want to,
Yeah, well, we can leave that. But so what we are, our reserve is that we reserve the estuary part itself, both as a habitat for our migratory birds, both to keep it in focus of what it was on a traditional basis or on a intergenerational basis, and our efforts. And I'm pleased to be able to say that our efforts in that are generally agreed to. But the other one is, if persons can walk over the dunes with due diligence, experiencing is being able to appreciate the environment. But to put signs up and say no access, no access, no access gives an anti-bureaucratic feeling, and it's not serving a social protocol or a social emphasis to what we would like to bring about.
thank you, Kelvin. Are there questions? Point is well made. Thank you very much, dear Ray. And could we welcome now Ian Hutchings? Welcome, Ian.
Hi, good morning. I represent the Cross Country Vehicle Club, which is a Wellington-based club. We come to this from a perspective of saying we've had members who've had homes in the Fox's Beach area for many, many years. As such, they've enjoyed the beach, they've participated in community activities, volunteer events, and indeed, you've heard from Grant that they have been well respected in that area. But if I come to the bylaw you propose, I think I'd say it's part of a toolkit. And without getting into the detail of what is in there, basically, you've got other things in your toolkit you've got to use as well. Just passing a bylaw by itself is pointless. What you need to do is to have a comprehensive overall plan which says you've got a bylaw, you've got provisions to restrict the public, tell them what they should do, you've got to educate the public by signage and, where appropriate, physical controls. If you don't do that, you won't achieve an outcome. You'll just continue doing what's been going on at the moment. Because people, there are lots of laws around, people respect them when they know there is some consequence of not respecting them. So you need to have active educational processes, you need to have enforcement processes, both probably what I call soft enforcement and hard enforcement. If you don't do that, well, it's the old TV commercial. If you keep doing what you've always done, you're going to get what you've always got. I've heard there are different nuances about how traditional accesses should be allowed and the like. In that regard, we'd simply note that we use the Mackenzie Trail, which is by virtue of a council permission. We wish to continue doing that. It's not part of the dune system, well, not part of the 4 dune system. It's well away from the beach and causes no environmental concerns. But we are concerned that there is environmental problems on the beach. There are what I call irresponsible hooning problems on the beach. And you need a tool to do something about it. If you don't have a tool, you're just whistling in the dark. So we support the bylaw, and you may be able to get a better bylaw with public beach access bylaw, as is sort of noted in the officer's comments. That's a new ballpark down the track. If you wish to do it, good luck. But in the meantime, our question is, do you support the bylaw? Our answer is yes. Thank you.
Thank you. Points clearly made. Any questions? No, that seems. Thank you for your presentation. And Health New Zealand. Oh, Sally Dara from Health New Zealand. Yes, thank you. Welcome, Sally.
Kia ora koutou koutoa. Is that on properly? So I'm from, my name is Sally Dara and I work for the National Public Health Service, and I know this is a really confusing space, so I'm going to explain who we are. So we are part of Health New Zealand, so we're the kind of the public health arm. And in this district, so I'm submitting on the proposed permit conditions with regards to smoke-free and vape-free, which we fully support. So our work that relates to these things is we have our smoke-free enforcement officers, smoke-free, vape-free enforcement officers. So they monitor compliance with the smoke-free and vape-free legislation. They do such things as checking that our shops are complying with the legislation and that they're not selling to our youth who are under 18. And they actually test this piece of law by doing a thing called controlled purchase operations, where they send in a volunteer who will attempt to buy the product, and then a shop may be fined if they are selling. We also have public health nurses. They work in schools, they do immunisations and run health clinics, and for them vaping has been a really huge issue which schools have been trying to work through with them. And I'm part of the health promotion team, so we work alongside communities around health and wellbeing, and for communities to meet their aspirations around that. We also work alongside other organisations who have an interest in smoking and vaping, such as the Cancer Society and our time team who work with people who are trying to quit smoking. So we would just like to say, congratulate you on looking to put those permit conditions in around smoking and vaping. We think that in public places, we think that is a really good move which will improve the health of the community, and also it is something that actually supports a lot of the other work that's happening in this space that we're involved in. And so we just wanted to make a recommendation, which is in my submission, which you've hopefully got now, and that was that in section 9.6 is that there's a bit added, and that's if tables and chairs or other seating arrangements are placed on the footpath, then smoke-free, vape-free signage must be present and displayed at all times. No ashtrays or other devices intending for collecting ash may be placed on the tables or seating arrangements. And I think we also, alongside the Cancer Society, worked along with Palmerston North City Council with the implementation of their smoke-free, vape-free permit conditions. And I guess some of the things we learnt there was that signage is really important, and also positively promoting the permit conditions, both with businesses and the community. And that is on an ongoing basis. And I guess that the other thing is that we are happy to help in any way that we can with advice and support, and any work on the policy, further work on the policy or other policies relating to health and wellbeing. Thank you very much for having me today.
Thank you. Are there any questions? Mayor Burney.
Just a quick question. Is there signage that is standard for that sort of appropriate place? That
is the best thing is probably to liaise like with Palmerston North City Council, because I know that they have accessed signage for that purpose, and so that's something that you could work together on, I would think. And I know that they were re-looking at that signage, and there's also sort of for outdoor places, there's some standard kind of green signs that we can, tell you about, forward the details for.
It just seems, if 67 territorial authorities are having their own signage, it seems a bit silly, to be honest.
Yeah, well, I think there probably is standard signage, so I'll just have to double check on that one. Yeah.
Thank you. No further questions? Thank you for your submission. So, councillors, could I take you back to page 9 in the order paper now? We're back with the transport bylaw, draft bylaw, page 9 at the bottom there, the roadside grazing and fence encroachments, and the recommendation flows over to page 10, the recommendation that we maintain current policies regarding roadside grazing and unformed roads, without designating one side for specific recreational use due to budgetary and practical constraints. Are there any questions of officers? Appear to be none. Is anyone prepared to move that? It's moved by Councillor Jennings. Is a seconder for that? Mayor Burney seconds. Discussion? Okay, appears to be none. In that case, I'll put it. Those in favour, please say aye. Against, say no. That's carried. And we move to the pay by plate and installation of the new Park 120 car parks. The recommendation there that changes to the pay by plate and installation of the new P20 car parks be adopted as proposed. Any moved by Councillor Tamihana, seconded by Councillor Jennings. Is there any discussion? Appears to be none. I'll put it. Those in favour, please say aye. Against, say no. That is carried. And we come now to the enforcement of parking restrictions, and the recommendation para 33 to retain the current bylaw provisions as they provide the necessary regulatory framework with enforcement continuing to follow the existing operational policy. Someone prepared to move that? Councillor Jennings.
Happy to move it, and then I've just got a question for
question, sure, yeah.
Did you want to launch into that now?
Yeah, launch into it.
Yeah, so look, support the wording of the bylaw and the recommendation. The question is, obviously we are about to embark on a whole lot of work around, particularly the Vin Town Centre, and there's going to be some specific, likely to be some changes around parking or position of parking and that kind of thing. And so I just wanted to clarify that the bylaw and this particular part of the bylaw sets the frame, or it provides the tool in order to set particular restrictions or requirements in future. It doesn't so this is sort of the enabling piece of the puzzle, that there's further opportunities to define what the restrictions are, where they're going to be, all that kind of thing later, that the bylaw isn't the end of the story when it comes to the conversation that might happen with the community around changes in particular parking arrangements. Is that?
Thanks, Councillor Jennings. So I understand the question correctly. So yes, the bylaw sets the framework there around setting of parking restrictions. So one of the very first clauses is around by resolution of council, or says by resolution of council. So it's not a council officers go out there and just make the decision to change the parking, but that there is some, and in the case of the town centre strategy, there is some work that's been done to identify that there are other changes that need to happen to those parking areas, that then comes back to council to make that decision for changes.
And with that answer, are you prepared to move the recommendation? Councillor Jennings moves. Is there a seconder for that? Yep, Councillor Tamihana. Discussion?
I don't think it needs much discussion, other than say that obviously this is setting the groundwork for the politicians to make subsequent decisions, and I think that there's a clear process that will allow for community to have feedback and input into any of those decisions, but this is about setting the framework. So
thank you. And just segueing off that too, I was very mindful of Carol Dyer's submission, and although we need to separate the operational impact from the bylaw aspect, I think I'd just like us to note that it may be worth considering in the next annual plan round that we consider the budgetary the budgetary requirements to successfully police the enforcement around car parking. So I'd perhaps not move it as a formal motion, but could we just note that, is the committee happy if we just note that that's something we could be alerted to in the next annual plan round, because there are serious constraints obviously in actually implementing the policy. So thank you for that. So that's been moved and seconded. Any further discussion? Appears to be none. I'll put it. Those in favour, please say aye. Against, say no. That's carried. Bus stops and traffic management. The recommendation on page 11, clause 36, no changes to the bylaw are necessary regarding the bus stop notification process, as this is managed operationally and can be refined as part of broader planning and consultation improvements. Any questions of officers or like to know? Happy to move. Moved by by Mayor Burney, seconder. Is there a seconder we need? I'll second it. Councillor.
I just had a question for officers.
Oh, sorry, my apologies.
I guess the main submitter who raised this appeared in their personal capacity. However, he chairs also the passenger transport, and I wondered if he knew something that was coming that we didn't around bus stops, why he raised it in the first instance. I guess I just want to be really sure that if that is the case, we have the flexibility to introduce bus stops in the near to medium future without having to go through a full review of this bylaw, of this particular nature or piece of the bylaw regarding bus stops.
My only comment would be that with the change in the GPS and the lack of funding allocated to public transport, there's very little chance that we are going to be given any public transport services in the district in the near future. So this to me is, they're stopped basically. So I don't think there's any value in us exploring future bus stops until we get some guarantee around delivery service.
And it's not coming soon either. Okay.
Okay. Righto, so we're ready to put the recommendation. I'll put it. Those in favour, please say aye. Against, say no. That is carried. And that brings us back now to page 8, recommendation D, that the committee recommends council adopt the land transport bylaw, noting the changes. There were some foregoing recommendations. So, yeah, we've already done that, haven't we? Yeah. So, nothing.
So that the committee recommends council adopt the land transport bylaw 2024, noting the foregoing recommendations, which is what we've just worked through.
Happy to move that. Someone, Mayor Burney moves. Councillor Jennings seconds discussion.
Just a question.
Yeah, question.
At least 3 submitters, or 2 that I can recall, that spoke today, raised, and they highlighted the intelligent, and they are, yet they struggled to, when they read the bylaw, the language, and I just wondered, could we note that about improving some of the, simplifying the language so that people can understand it a bit better? I'm sure you could deliver the same message in better. I know where they're coming from, and I just, if we just, and it's not the first time we've been told, I just wonder if there can be some improvement in that space.
And council officers will note that. Thank you. And with that in mind, I'll now put it. Oh, sorry.
Sorry, Mr. Deputy Mayor. So the only things that I just wanted to question was there was some. Obviously, we had some discussion about, and we had some submissions about the definition of berm, and there were some other small feedback pieces around that. And I just wanted to give officers the opportunity, like having heard the submissions, is there any changes that you might want to recommend or consider? Because certainly in the berm space, the outcome that we're trying to achieve is really clear. Like, we're trying to protect council infrastructure. But is there some accepting language or ability to give us some language in there that allows us to designate certain areas as okay, even though the default setting is that it's berms are a no-go? So can I just hand that question to you and sort of get, is there any changes you would potentially consider or recommend before we adopt or recommend adoption?
And it was specifically Waitarere Beach Progressives, I think, made that point. Yeah. James?
Thank you for the question. In my view, something we could have improved with the consultation document and the bylaw itself is, I think we've given the impression that we want a blanket ban on parking on the berms, and how I'd like to approach that is when we move on to doing education and media release about the bylaw, and we do that communication piece for it. We really lay out how we will approach enforcing. I believe the submissions made some very good points, but I can see challenges with including changes in the land transport bylaw itself that might restrict us, and I really think we need that flexibility. As an example, there was the question around changing the definition of a berm to be either past the footpath or past a formal curb and channel. That may make sense in a lot of circumstances, but in other circumstances there would still be problem areas. With designating a specific area that would be, say, exempt, it may be a challenge. It may be fine for a car to park there. It may not be fine for a logging truck to park there. And it becomes more and more complex, more and more bureaucratic to handle this in a bylaw. Whereas if we can handle it in the policy with common sense enforcement, we can handle those issues without a burdensome process.
So, what would your response to a suggestion? And so, I think 32.7 is the relevant clause. So, having an E there that says so, except where expressly authorised by council, something like that, because that gives then you an ability. So it retains the default position that berms are a no-go, but it gives you an ability to specifically or expressly authorise in writing or by signage or by map, whatever, certain areas, and that's more consistent with the recommendation that we made. So that's just what I'm putting on the table with you. That kind of really small language, whether you have any objection to that, because I think it just might give us a little bit of discretion and flexibility, but not take away from the overall objective.
In my view, I think we could work with that. I would defer to my colleague Waimawana on the final say on that particular.
Thanks, James, and Councillor Jennings for the question. Yes, we could work with that. I guess a challenge that might be posed from that, though, is where actually, no, now thinking about that a little bit further, yes, we could. And we could manage that through permit conditions. For example, if we were to give a permit process, and if you look through other clauses within the bylaw we've talked about with permission of council, so the permit process and having conditions, we could do that. Now, my main basis for saying with conditions is that we might give permission for this section of berm to be used, and they may be using it really well. And then along comes a large vehicle or something that causes damage. We want the ability to actually be able to do something with that. Yeah.
So just for clarity, could you just repeat your suggested wording?
So I'd move that we recommend adding the language to clause 32.7, E, as authorised. What did I say? Oh, damn it. Except as authorised, except as expressly authorised by council, or permitted. Maybe that's authorised or permitted.
I would suggest permitted, simply for the fact we've used that throughout the document already.
It's E as expressly permitted by council.
That has been moved. That wording has been moved by Councillor. We'll just play it. So, by Councillor Jennings, is there a second? Councillor Tukapua seconds. Any discussion? Further discussion on that? Okay, I'll put that then. Those in favour, please say aye.
Aye.
Against, say no. It is carried. Thank you. Now I've forgotten where we are. Because we haven't done the
I've got a question for clarity. I was going to raise it right at the beginning of the submitters of this particular bylaw. And because of time, I just parked it and I asked Sam, but he's probably right, but let me just double check. Parking on the berms being vehicles, you mentioned log trucks and so did submitters, but what about the rail, those containers? You know, people buy them for storage, and I have seen them parked on berms. Sometimes even caravans. So, is that adequately captured, those containers?
I can answer the question if it's covered by 32.8. So I think that although it doesn't talk about specifically berms with any road or public place, so it includes berm. Yeah.
Sorry, just to add to that as well, we would that is compliance team. We would typically approach that through the Public Places Bylaw in terms of the container there, on the public place being the berm.
Okay, so we now move to the global recommendation, which I think has been moved and seconded. No, not yet. Someone prepared to move. Moved by Councillor Jennings, seconded. Mayor Burney seconds. Any further discussion? Right, we'll put it. Those in favour, please say aye. Against, say no. That's carried. And that is.
I just actually, I noted something here earlier and I just realised that I haven't asked for clarity around it. This is the bylaw stuff we just did. It was around the Macca transport. Oh, that's in the other one, eh?
Yeah, we're moving now to the public. Do people want a 5-minute break? Yeah, I think we'll do, but we'll be very mayoral about it and say 5 minutes only. Okay. Places Bylaw. We've received it. So as a first step, the opportunity just to get an where's our officers? We'll just, no, sorry, we'll just pause till we get the officers back. The intention being that there be officers give a bit of an overview, having heard from the submitters, and then a chance to flag any issues.
Question for you, Mr. Chair, without the staff present, doesn't matter. Conscious that we've obviously got a time window as well today in terms of the availability for this hearing. And so there was probably more to reflect on in terms of the Public Places Bylaw than there was the last bylaw. And so going through this recommendation by recommendation, then also pieces of the bylaw wording itself, I'm just conscious that that might take more time than we've got available. And so what is the process in terms of do we just box on and try and do as much as we can, or do we essentially potentially recommend that we do a little bit of workshopping or a further session? Yeah, I'm in your hands.
So my intention is to try to box on. I did speak to the Mayor earlier. Are you comfortable if we do go a bit past the 1 o'clock? Obviously we're going to go well past. Workshops, we just need. The other option is that we reconvene tomorrow, if that works with panel members tomorrow morning. But Mr. Mayor?
The other option is that we are due to finish at 3 o'clock today. We could reconvene after that, and I'd rather do it in one session, to be honest.
There's noddings of head, so reconvene at 3. Okay, thank you, and thanks for the question.
So, and just in terms of structure then, and bearing in mind the Mayor's comment to try and do it all in one block, could we then perhaps use the time we have now to perhaps get the officers to reflect on anything they've heard today and answer any questions and provide any further commentary in terms of any of the suggestions that have been made? And before we get into,
exactly what I think I said. I might not have expressed it well, but yeah. So who am I? Are we talking? Yeah. So overview by, and then there may be some people want to flag issues.
Thank you, Deputy Mayor Allen. So just an overview of what we've heard today in relation to the Public Places Bylaw. So we've heard around particularly the new introduction of the beach access provisions. We've heard quite a lot of submitters speak about some need for further clarification on what access means, so walking access, vehicle access, being really clear about that, which came from Sophie Campbell. We also heard from submitters around clarification, or actually some suggested changes there to the wording around particularly walking in the dune areas. So actually looking at making some amendments there, and I would maybe suggest that councillors consider, or the committee consider, whether we need the words walking in that particular provision. We've heard from submitters talking about the need to preserve or have a tool in our toolbox around being able to restrict some of the activity or control some of the activity that's going in there, and some support to do that, particularly around the estuary and Ramsar site. But actually that we need to be clear around, particularly in that dune area again, people who are using that responsibly, being able to walk through there and actually, make the most of our wonderful environment, and certainly that wonderful environment out there. We heard from a couple of submitters there around the Mackenzie Trail and some users of that particular facility. So again, making sure that our provisions are clear around the access and enabling the access for that and the continued use. We also heard from submitters talking about their support to the smoke-free and vape-free provisions in there through the permit process as well, but also around maybe detailing out a little bit more around what the permit looks like for that, and encouraging that there's no ashtrays and sort of items that are put out there that would encourage people to sit there and to smoke and vape, and the use of signage. I think in a nutshell that covers off the notes that I had. Certainly there are a number of recommendations that have been made to the committee from the submitters that have spoken to us today and in the written submissions that encourage the committee to consider those and any changes or amendments that are suggested to officers.
Thank you. Are there any further points that hearings committee members want to raise that have not already been covered? Councillor Jennings?
Yeah, so just to reflect probably on section 3, which is around the purpose clause, and there was the good suggestion from Grant around that. And I kind of thought also, having reflected on some of the other submissions and also kind of dealing with the fear that the bylaw is about restricting staff controlling this, whether we could have some sort of other wording in section 3 that kind of, and this is unpolished, so just bear with me, but sort of like maintaining equitable access to public spaces except where reasonable controls or restrictions are appropriate. Something that kind of reinforces that the whole idea of the bylaw is to kind of maintain that free access to public places, but acknowledge that there are going to be some reasonable controls and restrictions sometimes. Like, I know that that's the overarching purpose, but I think a statement up front alongside the addition of that principle around protecting the natural environment, I think that would be beneficial and sort of enhance the whole overall sort of just thrust of the bylaw. Yeah.
No, good. Thanks for any further things? No, Councillor Tamihana?
No, I really like that additional wording there. I think it does give a bit more scope and ability to be more flexible around stuff. Look, a couple of things I wanted to note there was probably the languaging that we're using and the, what we heard today from a couple of submitters was around feeling like we need a permit to go to our spaces. So I'd like to ensure we're removing that language and having a language that actually shows that they actually have full access and usage of areas as identified, as described a little bit by your comments here. But we just need to get rid of this thinking out there that families can't use our spaces without coming asking our permission, and that's really important for me. I did want to follow up on the Macca one through you, Mr. Chair. I'm a little bit concerned about the use of Macca because I'm not sure how this council implement Macca legislation when they're not a Macca interested party. And so probably what I would like to have considered is that within that bylaw we must acknowledge our iwi and Macca somehow. I don't know what the right wording is because that process is still ongoing and we don't know how it will or won't impact on any bylaw we potentially put in place. What I'm not prepared to do is disconnect cultural connections, and because Macca is very much based around cultural connections and community connections, and so I'm just being cautious that when we're using that type of language we're ensuring that we're not later on jeopardising the ability for whatever the Macca output is, that we can apply it within our district without going through a full process to acknowledge that space and that legislation that sits around that space. So I hope that's not being too complex, but in my mind I'm really, really cautious about limiting cultural access is huge for me. Not just, and I mean all culture, not just mean Māori. Really happy with the clarification around these are tools to assist council when they're appropriate to be used. Again, really important languaging. And I really like James' comment around the comms and the media releases that are coming out of this and how we need to be so very, very clear with the intent and the messaging we're giving our community around why we are making more rules or maybe amending rules that were already in place. So those are my final points, Mr. Chair. Thank you.
Can I just check something? Just a follow-up question for officers. So I could be wrong, but the permitting, when we use the permitting language, so we use it in sort of two ways. We permit an activity, permit an activity, or we permit as an issue a physical permit, and that the physical permitting is in relation to fireworks and there was one other one, but yeah, is that just to clarify that based on Councillor Tamahana, is that?
Yes, as well as exclusive use of a public place, so things like dining and alfresco dining at Main Street.
Right. Okay. So, in the hands of the committee, we can start the process now. Happy to make a start, kick into the recommendations. Are we happy to do that?
I just
Give it all till the 3 o'clock.
I was hoping to take off for a quarter of an hour, to be honest, because I did have a 12 o'clock appointment and I don't want to disappoint them completely, if that's okay.
No, I think in that case, given it's only, it's kicking off in 20 minutes is the workshops, isn't it? So I think we'll just, we'll adjourn until 3 o'clock, until we finish the workshops. Yeah, okay. Thank you.